Hi, Rick Martin here with Martin IP Law Group. This week we're talking about the U.S. Supreme Court again, and this is the third time in just the last month or so that they've dealt with an intellectual property case. Now here we are with another case involving Apple, Broadcom, and Caltech, allegedly infringing chips that were used in iPhones, iPods, iPads, and Apple devices. That case started in 2016 when Caltech sued Apple and Broadcom for patent infringement, alleging that certain patents owned by them were in those chips that were in Apple phones and Apple devices, and that infringed Caltech's patents. In response to that, then Apple filed administrative action with the U.S. Patent Office to have those patents declared invalid. Instead, the USPTO in that administrative proceeding actually upheld the validity of those patents. The lawsuit, meanwhile, resumed, and in 2020, a jury in Los Angeles, California, found Apple and Broadcom liable for patent infringement and awarded $1.1 billion to Caltech for damages in that case. The issue on appeal really was the federal courts precluded Apple from raising certain issues that they did not raise in the proceeding before the USPTO. The Federal Circuit found that that was appropriate and that should not have been allowed, and subsequently the Supreme Court again refused to hear that case. And so now where we are is that case has been affirmed on validity and infringement of the patents, but it's now being kicked back down to a lower court for a rehearing on damages, which were previously assessed at $1.1 billion. So we'll wait and see what happens there with damages, but it looks like Apple and Broadcom are going to have to pay something, and something probably near $1 billion to Caltech for infringement of this patent. Thanks. We hope you found this interesting. And if you have any needs with regard to your intellectual property, feel free to reach out to us. We're here to help. Thanks. Have a great weekend.